go live button. We have a live edition. We're covering a live court case today. We're talking about George Allen Kelly. His preliminary hearing is in about 10 minutes from now. We, of course, know him as the Arizona rancher, the gentleman allegedly who murdered a illegal immigrant, illegal migrant, confused tourist, a lot of different ways you could call it. But this is a case that we have been following since the inception. It's actually very new, very fresh. And so I want to take a quick look at the court docket. You can see actually the court has shared with us the live link. It's available on YouTube. It's on Courtroom 3 is the name of the channel. So that's where we're going to be tuning into. But I wanted to show you what the court docket looked like because this is where we left off the last time we were here on this channel talking about George Allen Kelly. Remember, the initial appearance was back on 131. We actually watched the arraignment here, so if you missed that video, we covered it previously, and it is available, of course, on this channel. There were a whole slew of motions that were filed. There was a long-form complaint, and we read through that in detail back when we covered this the first time. There was a hearing. There was a motion to continue that we covered. There was a notice of appearance that was filed, and you may remember last time we read through in great detail the motion to modify release conditions. So George Allen Kelly is the rancher who is in custody. He's got several charges, and he is trying to get out of custody. The judge is holding him on a $1 million bond, and a lot of people are saying, wow, that's a lot. That's a pretty stiff penalty for something where the evidence might be a little bit questionable, and I'll explain what I mean here. But there are other people who are out on, out on release, $50,000 bails, and, much lower thresholds for them to be released and earn their freedom, so to speak, whereas George Allen Kelly is not. So there was a motion to modify the release conditions, and when we covered that motion, there was not the opposition. Okay, so the government filed their opposition yesterday, the day before the hearing, and that means, well, I don't know if we're actually going to hear this argued today or not. This is scheduled for what the judge calls it a preliminary hearing, but all these filings are coming in pretty rapidly. Like generally you'd have an opportunity to reply to a response. And so it's all happening pretty quickly. So I'm not real sure exactly what the judge is going to want to get into today. Normally these preliminary hearings they can be very short. They can be very long. If you actually conduct the hearing, the judge can use these hearings as placeholders and then just sort of address other issues like motions to modify release conditions or issues with counsel or issues with discovery. And so they can just be kind of called placeholders. And so it may actually not be a preliminary hearing. I don't expect it to be. The judge evidently only scheduled this for about 20 minutes, so 9 a.m. to 9:20. So I don't expect it to be, full hearing when everybody comes in and tries to establish probable cause, but that's the common vernacular. A lot of other people will say, well, what happens at a preliminary hearing? And that's what it is. So this is what the docket looks like. We had a couple new filings that came in yesterday. I wanted to show you, we had the amended complaint. So we had a previous complaint, and I think the original complaint was just the murder charge. So they've actually added on 2 additional charges, and we can go ahead and double check that while we're here just so that we are clear. The original long form complaint was this document, and yeah, this was the original. So they filed the first degree murder charge. That was back on February 2nd. You can see that was the original, and we now have a new charge, 2 new charges that got added. So in addition to the first degree murder charge, we now have aggravated assault, dangerous nature. So using a rifle, deadly weapon, did place RFG. Okay, so look, we have new people now. We have new witnesses, evidently, some other initials. So we have GCB, which is the murder charge. So this is the person who is deceased, GCB, and they identified that person. But we also have another person who is RFG, which those were my old initials. I got that changed. But those were my RFGs, the other person. So presumably that was the person who was also, I guess, lost at the border or touristing the country or something, also at the border, and they were together. And so presumably law enforcement met up with them. Here's another person, also aggravated assault, DRR. So these may be 2 witnesses who are telling the cops, no, yeah, he definitely shot GCB. And he scared us. He was pointing a gun at us. He was firing at us, something like that, right? And that's why they are witnesses now. So this got submitted 2/21/23. Let's see where we're at with the court. We got about 5 minutes left there. And so we have the new amended complaint. So now he's facing 3 charges instead of 2. And we'll hear the judge probably read those in today and sort of arraign him on those charges today. So he'll, okay, you also been charged with this. You've also been charged with that. You understand? Yeah, all right. And if you have an attorney, basically the same thing we covered at the last hearing, the judge will do the same thing again, but for the new charges. And so we'll see that, I would expect, today. We'll also take a look at this notice of appearance. So we saw this one was filed on the 8th. This one isn't new, but just so we know who we're sort of talking to here today. Brenna Larkin is who I expect to be the attorney for Mr. George Allen Kelly, who will be in the courtroom this morning when the case starts. But if you recall, there was also this motion to modify the release conditions, okay? And this was something that I was a little taken aback by when we read through it the first time. And this was submitted by that Brenna Larkin, who is the defense attorney for Mr. Kelly. And this was a little bit shocking, actually, because he is in custody on a $1 million bond, which is, a pretty serious bond, right? It's actually it's a nice chunk of change. There are other people who also get charged with homicide, the death of another person, and they are in different categories. This is a first degree sort of intentional murder charge, right? Let me make sure we're clear on that one. Yeah. Intending it would cause death with premeditation did cause death, right? I mean, that's a serious claim here. It's like he woke up, said, I'm going to go kill this guy, and went and killed him. And so that is one factor as to why this is a $1 million bond, but there are also people who sort of are in very similar circumstances who are not out, or who did not get $1 million bonds. Okay, but the point is, we had the defense attorney, Brenna Larkin, submit the filing and go from a $1 million bond to a $0 bond. Okay, like that's the range, and that's a big range. All right. Typically, you'll see, it's like a big ask. You're swinging for the fences on that one. The judge said, look, this is a serious case, $1 million. I know this guy doesn't have $1 million, can't come up with it. It's basically non-bondable in practice, right? He's not going to get out practically. So the judge knows that. And for a defense attorney then to come out and say, well, judge, I mean, you decided it was $1 million, but you were so wrong that we're going to be asking for a 0. Right? It's a whole different category. So we have the notice of appearance, and I want to show you just briefly what Miss Larkin was explaining as the defense. And she, I think, did a great job here. She said, look, she explained the whole story. She said that they were there were gunshots, there were these guys armed with AK-47 rifles, dressed in khakis, camouflage clothing, running all around. Mr. Kelly is in a very southern part of Arizona, like basically right on the border. So they called the Border Patrol multiple times. Border Patrol knows that there are these people all over the place. Mr. Kelly took care to aim over the heads of the armed group of men, fired a shot into the air. Group fled. He walked over to the barn. Now, if you read the rest of this, as we did previously, they say that there was sort of a back and forth. Cops leave, or the Border Patrol leaves. They come back again. Border Patrol leaves, come back again. There's all this sort of, detail. And what ends up happening is Mr. Kelly walks out there, finds a body, finds that he is dead, does not believe any of the warding shots could have possibly hit anybody. He's firing into the air. And so he calls the police. Hey, there's a body here on my property. I have a big ranch down here in southern Arizona. So the cops come. They say, oh, perfect, you murderer. You're under arrest now. And as we're reading this, we're going, okay, well, do they know it's his gun? Do they know it's his bullet? Specifically, do they know that he shot him? I mean, what's the evidence of this? Because it sort of felt like maybe somebody else shot him and just left him there and just, carried on. It felt like he was kind of robbed, because as we were reading through this, he didn't have much on him. And so this is about the evidence. And remember, in America, currently still kind of, we have the presumption of innocence, and you're supposed to be presumed innocent. And so the court should theoretically do everything they can to allow that person to maintain that level of freedom as best they can throughout the pendency of the case, right? If you are sort of being prosecuted, but you're basically being treated as though you're guilty throughout the entire criminal proceeding, is that really innocence? Sort of, not really. I mean, we talk about it all the time here, that the penalty is the process, essentially, right? The process is the penalty. Even if you're acquitted, exonerated completely, how much do you spend on lawyers? How much time do you spend in custody? It is a big burden on anybody to have to engage with the justice system. So we have this situation where they're saying in this case, the evidence is extremely, extremely weak. This is a defense attorney speaking, right? Saying, look, I've seen it. Kelly fired shots. He's done everything that an innocent man would do. He cooperated with the investigation and law enforcement. And there are many other explanations, right? He could have actually taken the body out there and sort of, dumped it into the wilderness. Uh-oh. Are they? Let's see here. Uh-oh. The video has been removed by the uploader. Uh-oh. I wonder if they're not going to be live streaming this. Uh-oh. I'm going to be very unhappy if that's the case because we're all here in attendance. And hopefully they didn't delete it. Let's see. We're going to take a look and see if they have a new hearing schedule. And if anybody out there has, oh, yeah, video has been removed by the uploader. Oh, very interesting, my friends. So if anybody is out there trying to dig this up and you happen to have a link, we had it up and earlier available, but now it has been removed. So let's see if we can dig it up somewhere else. What a bummer. Yeah, so we're going to do a refresh here and try to dig this up because they linked to the original, right? This is the court. They linked us to this link. Here's the video. Oh, removed. Oh, very interesting. Very interesting. All right, so that was out of the courtroom 8. Now, I don't even know if they have a sort of an identified channel. See if I can identify. No, I mean, I can't even identify the channel. I mean, good Lord. All right, so here, I'm going to drop the link in the YouTube chat and the Rumble chat and the locals chat. And that's definitely down for you guys, right? So we're going to see if we can catch it. And they pulled it down right before it was supposed to go live. Video removed, says Patrick Vanderland. Very, very interesting, huh? Yeah, I'd like to see what's going on with that. So all right, so we are trying to dig this up. They may have just pulled it down. If they pulled it down, that's okay. We'll read the motion to modify release conditions response by the prosecution. So we'll still have something to talk about here this morning. However, we're going to see if we can dig this up. So it was the video for the preliminary hearing that was supposed to be scheduled today. They actually had a YouTube link that they published for us to join in on, and then they deleted it. All right, so let's see if we can find their YouTube channel. And we did, but I'm not sure that they're broadcasting anything. They may have taken it down. Very curious. I mean, they may just not be broadcasting it, is I guess my point. Yeah, we've got the Board of Supervisors. Bummer. Well, we'll see if they refresh this for us, because I think what they may have done is just created like an unlisted link. Yeah, video has been removed. Which is yeah, I think that's a very interesting thing that happened there. Now, I do know that there are some other reporters who were in the room who were there. Let's see if we can identify anybody. Yeah, the hearing was scheduled for 9 a.m., but I'm not seeing anybody with a stream. Very interesting. Okay, so we don't know, and we don't know actually if the hearing is even taking place. But this is what we got from the court website. We just did a refresh over here. And of course, and you know what now is also happening? Look at this. This is very strange. Okay, look. So when you go here, this is the high interest cases. Okay, I just showed you the court docket, right? Now they moved it. The heck is going on? Okay, so look, right? They literally just moved it. Okay, so here is the link. Like I just showed you this about 10 minutes ago. Okay, before we started this stream. State of Arizona versus George Allen Kelly. We got that there. Click the link for the case number that brought us to the docket, the one that I just showed you 5 minutes ago. Here, we're sorry, this web page is not up anymore. So the video is down and the link to the docket is down. Okay, I guess that's the end of that one. Is he free? Did they dismiss this case? Is he free? The heck is going on over here, man? All right, so we'll keep poking around and see if anything develops in the meantime, but this is a little bit strange. Now, all that being said, let's take a look at the response. So since we're here, and we now know that he's got two additional counts. So we've got ag assault and ag assault for another person. So DRR and RFG. We also have the response. So we read our notice of appearance. We talked about the motion to modify the release conditions. He's got no criminal history. Family's there, super supportive of him. I think they were even there in the courtroom. Has been ranching for a long time, never used drugs, not even marijuana. The guy's, a stellar, upstanding citizen. He's currently on 23-hour lockdown. They brought out 4 different guards in the courtroom. And they say that based on all of this evidence, $1 million bond is nuts. All of this should be dropped down to nothing, right? He should be released on his own recognizance, is what this attorney said. And so Samantha's here, says, Rob, read your chat. And this is a court case. Yeah, somebody says this court case is very open and transparent as the Arizona election. Yeah. All right, I'll keep reading the chat. Definitely. Thank you, Samantha. Fox News is showing they're waiting for the event to begin. All right, well, we'll see if a stream pops up. If anybody out there is Google Google smithing or YouTube smithing or whatever, and you can dig up a link, please do let me know. And I'm going to open up another Twitter tab. All right, so you can see this was their motion to modify the release conditions. And the prosecutors, of course, responded to this. And we can take a look at what they said here. Now, they write, government prosecutors in Santa Cruz County Justice Court in Arizona, shout out. They write, the opposition to the motion to modify the release conditions. Of course, George Allen Kelly, the Arizona rancher charged here, has filed a motion to get out of custody. The judge, currently Emilio Velasquez, is holding him on a $1 million bond, and he doesn't want to remain in custody if a case like this has weak evidence. His defense attorney has said it is weak evidence and it doesn't meet the presumptions for sort of maintaining somebody of his background in custody this manner. So here's what the prosecutors are saying in response. They write, all right, Judge, we're responding to the defense attorney. They say the state believes that the bail imposed by the court in this case is appropriate. And the reasons for this opposition is more fully set out in the attached memorandum of points and authorities. They say the state further requests, pursuant to the rules, that the court order no contact between the victims' representatives, JR, YC, and DC, and two additional victims, RFG and DRR. They say, here are the facts. This is a government prosecutor speaking, writing. Many details of the investigation and the victims' statements are being withheld at this time because the investigation is ongoing and witnesses are still being interviewed. That's nice. Furthermore, the county attorney's office and the sheriff's department have all received disturbing communications, some threatening in nature, that seem to indicate an ongoing threat to the safety of the victims. Oh, great. So they're saying that they have to be, they can't tell us what the evidence is against George Kelly because they got some mean phone calls from the internet. And I don't endorse this, by the way, at all. You know, I don't want anybody calling or anybody dogpiling on this, right? We got to let the system play out. We're going to cover it here, no doubt. We'll do the dogpiling here. But, you know, the people in the courts, they're the people in the courts. And, you know, they're just trying to do their jobs like the rest of us. So, you know, I don't endorse it in any way. But this is not an excuse to withhold evidence, okay? Or to not give us the evidence or to not give George Kelly the evidence. This is a pretty serious case here. Obviously, this is going to be a case of national interest and national attention. And so, all right, that we're sorry that that's happening over there, you know, prosecutor's office, but at the same time, we got to get more out of you here. Kelly is charged with 1 count of first-degree murder, 2 counts ag assault. To date, 2 victims, RFG, DRR, they have come forward to report what happened when Gabriel, they call him, GC, was murdered. The victims report the following. They say, on January 30th, 2023, at around 2:30 p.m., a group of approximately 7 to 8 undocumented immigrants were traveling north through the Keno Springs area from Mexico. All right, so just so we're clear, the government is even acknowledging that these are, they call them undocumented immigrants. You might call them illegal immigrants. Depending on who you are, you might call them, you know, tourists or whatever, you know, whatever it is, however you want to phrase it. Okay, these are people coming across the border. They don't have a legal right to be here across the border. They traveled onto his private property. And so the government is even acknowledging that, right? Not a bad starting point, generally speaking, if you're a defendant, right? If it's your property, there's other people coming onto your property illegally. These are people who are, as we have heard, they have said that this is, the defense has said that they had, you know, weapons, camouflage. They look like they were menacing in nature. Other people had reported them. Border Patrol knew about them as well. So they're traveling north. Government acknowledges that they are illegal in the fact that they are not here legally. Okay. They say, contrary to Kelly's account, no one in the group was carrying any weapons. Okay, so it's a he said, she said situation. What is their evidence of this? It's the reporting from the illegal immigrants who are here telling you that they didn't bring any weapons when they were breaking the law. Well, that's pretty interesting. It seems like maybe that would be lacking in credibility a little bit. Would they say that they were coming across the border with weapons? And they just openly admit that to government authorities in the United States? No, obviously not. So the group, which included RFG and DRR, was within the sight of the Kelly residence when, out of nowhere, Kelly began to shoot at him with an AK-47. Kelly issued no warnings and made no requests, according to them. He just started shooting at them. We'll see. I mean, we'll see. Hopefully there's video footage. Hopefully one of these individuals got, this recorded on one of their cell phones, or there's, a Ring camera somewhere. Hopefully it's not just a he said, she said case, because that would be pretty crazy. Bonnie says court is live on Fox. All right, let's see if we can dig this up. We'll see if we can dig into this. I'm trying to find a link. If anybody has a link, that would be super helpful if you happen to have one. Otherwise, I'm going to try to dig into this. Okay, so Fox has it live. Yes, they do. All right, we're going to pull it up right now. Looks pretty quiet. We actually don't even see George Kelly there. And he's going to be right in this spot as soon as they walk him out. A lot more people in the courtroom today. During the arraignment, it was quite small. Or the initial appearance, you remember it was about, 5 people there. And it looks like we see a lot of George Kelly's family still back there. I think that might be his wife or sister. I think the kids were maybe there as well. But we'll say hello to the chat while we're waiting for the judge to take the bench. We got Neo Jades in the house. Samantha Richardson says, you don't just shoot into dark, visual. Brandon Rudder says this happened at night. It was, well, we can take a look. I don't remember the exact time. Here's a little bit of activity. All rise.
Please be seated. And if you can go ahead and bring out the defendants, please.
The judge said, bring out the defendant here, please.
Court is now in session. I'm presiding judge, Emilio Velasquez.
Good morning.
Morning.
All right, so we have, here he comes. They have him in a vest. Huh. So there he is. Let's listen in.
This is the time and date set for the law in motion preliminary hearing on case number 2023-041, State of Arizona versus George Allen Kelly. If I can have the state please identify themselves for the record.
Good morning, Your Honor. Kim Hunley appearing for the state, and present with me is Detective Jorge Aiza from the Sheriff's Department.
Thank you. And if I can have defense counsel identify herself and her client.
Good morning, Your Honor. Brenna Larson on behalf of George Allen Kelly.
Audio's pretty low on that one.
Thank you. So first, I just want to make sure that I disclose to Mr. Kelly that we discussed about the media being present. We asked the attorneys if there was any objection to file a motion, if there was any objection to the media. There was no objection to them being present, so at this time, we've allowed media to be present in
Good.
the courtroom. So first and foremost, it appears that there has been an amended complaint filed, and I think everyone has a copy of that in front of them. So it appears that you have two extra charges that have been filed. The first one is aggravated assault, dangerous nature, and the third one is aggravated assault, dangerous nature. And Ms. Larkin, did you want to go ahead and waive the formal reading of the complaint?
Yes.
And give a plea?
Yes, Your Honor, we'll waive a reading and enter not guilty.
Thank you.
Pretty standard stuff.
So I'm going to go ahead
Nothing
and
there.
proceed to the motion that was filed by defense counsel requesting a modification of release. Ms. Hunley, go ahead.
Your Honor, there is a housekeeping matter first, if the court would entertain that.
Go ahead.
The state filed its opposition and erroneously included two victims' first names.
Uh-oh.
We filed an amended opposition this morning, so we'd ask that the court seal the original opposition for the reason that we're attempting to protect the identities of the victims.
Very well. Thank you. So I did receive the amended this morning,
Uh-oh.
and we do have the original that we can go ahead and seal.
I wonder if they're in.
Very well.
Wonder if they're in our
So, Ms.
PDF. If they're in our
Larkin, you wanna
PDF,
go ahead and proceed
we'll skip them.
and discuss the modification of the release conditions.
Yes, Your Honor. Would you prefer if I sit or stand? I don't know what's easier.
That's it's up to you.
I'll just sit because the microphone's right there.
Very well. Thank you. And
Your
speak
Honor.
clearly into it. Just move the microphone closer to you so we can get a better
perfect.
better?
reception. That's good. Thank you.
About a fist away from your
And, Your Honor, the
face.
first thing I wanted to say is that we understand why initially Your Honor imposed the bond of $1 million cash in this case. Being a judge has its challenges, and certainly one of those is having to make important decisions with incomplete information. That's definitely not a job that I envy anybody, and I can understand why, considering how we don't get very many of these cases through this county, why it's prudent to err on the side of caution when the only thing that's known about the case is the charges themselves. Having said that, I'm glad that we were able to have an opportunity to review some disclosure in this case, to get the facts, and to try to make a presentation of those facts and of the law so that we can review those and make a more appropriate decision about the bond in this case. I'm not going to belabor the facts of the case. I think the pleadings that were filed by myself and by Ms. Hunley generally cover those. We obviously have a disagreement about what the facts of this case are. The state asserts that Mr. Kelly, with no criminal history, no motive for doing so, just essentially began opening fire on a group of unarmed people who were trespassing on his property. Our position is that that did not happen, that Mr. Kelly would not do such a thing, and that instead what happened was that he was approached by armed men who were on his property. We've discussed that in the facts section of our briefs. The facts are not here to be decided today. The only reason we bring up facts in bond hearings is because one of the factors, among many, that Your Honor has to consider is the nature.
Jorge, move your butt.
The facts are the facts. What I did want to discuss, and what became apparent after being able to review this case, was that there's a huge divergence in this case from how an investigation and prosecution should happen and how it did happen in this case. How a prosecution and investigation should happen is investigation happens first, and after the facts of the case are known, then charges follow after all of the facts have been thoroughly investigated. Facts like forensics, facts like ballistics, facts like autopsy results, facts like results of cell phone forensics,
Right.
shooting reconstructions, fingerprints, DNA, etc. Those are all facts that need to be determined by an investigation, and those facts should be determined prior to charges being filed. An investigation should be kept secure or secret or private so that there are facts that are only known to the police and that can be used to test any potential witness's credibility if a witness happens to come forward. Witness statements and witness representations should be evaluated before making judgments about what occurred, and witness statements should be evaluated based on different factors. A witness statement alone is not necessarily credible just because it's a statement.
Right.
Witness statements need to be reconciled or tested against certain things. The information given in the statement, the circumstances under which a witness is given,
Credibility.
other statements that have been given by other witnesses in the case,
They've already broken the
facts
law.
of the case, and the physical forensic evidence. All of that should be put alongside any witness statement before a determination should be made about whether that statement is credible or not credible. And the same standard of scrutiny should apply to all witnesses. The Alec Baldwin case comes to mind as an example here.
Yes.
A case where an incident occurred, there was a shooting, there was an investigation.
Good for her.
Following the lengthy investigation, then there were criminal charges. That's an example of how a criminal case
Yes.
should be handled. This case was not
Months.
handled in that manner, Your Honor. This case was charged first and investigated later.
Because they wanted blood.
Talked about the facts of the case. We've talked about the armed men that were seen on Mr. Kelly's property and the way he responded to that. The body that was discovered much later that was reported to law enforcement by Mr. Kelly. And almost immediately after making this report, Mr. Kelly was arrested. He had made no admissions that he fired a weapon at this person, or there
They
was
didn't even
no
have
bullet
ballistics.
that was discovered. No ballistics could be accomplished.
We're back.
There was no forensic reconstruction of the scene. There was a radio on the deceased and a cell phone on the deceased. There were no forensic investigations of those items. And there were no witnesses other than Mr. Kelly and his wife who had consistent statements. State nevertheless jumped the gun and decided to charge premeditated first-degree murder of Mr. Kelly. This essentially lit a match over a very intense political powder keg, and predictably, there was an explosion. This case has since been highly publicized, been highly politicized, and people have already prejudged this case very loudly on all sides.
Yep.
After this has happened, after this giant political and public explosion of the case happened, random witnesses start to come forward. These witnesses come forward very much after the fact. They come forward after
Weren't even named in there.
the investigation is no longer secure. The investigation is compromised by all of the publicity. Facts about the case are out in the media. They're available to the public. Essentially, anyone can come forward and craft some sort of version of what happened and provide some details that are accurate in order to claim to have been a witness to what took place. The witnesses that have come forward so far, there are two. The state asserts that there may be more coming forward in the future. I would not be surprised given the political and public nature.
Why not? Dogpile. Bring them all.
Show up.
Bring them all.
But the state does not appear to have vetted any of these witnesses or to have analyzed their statements to see if they can be properly reconciled to the physical evidence that we do have in this case. The state does not appear to scrutinize these witness statements in the same way that the state has scrutinized Mr. Kelly's statements in this case.
They took that. We just
There
read
very
it
much
in their
appears
motion.
to be a double standard for these various witness statements, and there very much seems to be a confirmation bias taking place in the investigation.
Awesome.
The witness statements of these people who've come forward are accepted as fact, and Mr. Kelly is assumed to be not telling the truth. He's subjected to a very high level of scrutiny. Today is not the day to go into all of the inconsistencies of the witness statements that have come forward in this case. I'm going to settle with just one example so Your Honor gets an idea of what's happening here. One witness who came forward asserted that Mr. Kelly came out and just randomly started shooting at people, shot this person from 10 yards away, and also shot a horse. This person was certainly not shot from 10 yards away. That does not comport with the physical evidence, and there certainly was not a horse that was shot or injured in this altercation. It appears from the summary that I received of that witness statement that the investigating officers did not even ask a follow-up question.
Amazing.
When this person said that Mr. Kelly shot a horse.
No, they got the answer.
That's what I mean when I say that these statements are not being scrutinized at all. They're simply being accepted as fact. And that's not how an investigation should run. That evidence is confirmation bias. I would also point out to the court that there's a very large incentive structure for people to come forward and to claim to have been witnesses to this event. People
Outstanding.
can possibly obtain immigration benefits for
Yep,
doing
outstanding.
so, or at least have the expectation of that. And people can succumb to pressure from traffickers who have an interest in blaming this event on Mr. Kelly. Testimony is something that is bought and sold by drug traffickers the same way that drugs
Excellent.
and people are bought and sold. It's a valuable commodity, and it is used by these traffickers to obtain what they want. In this case, the benefit they're getting is security for their smuggling route through Mr. Kelly's property, and they're sending a message to anybody else who might be defending his or her own property
Wow.
that if you defend your property against us, you will be arrested.
Wow.
And there will be witnesses who come to stand against you.
Wow.
So those statements must be scrutinized, Your Honor. And I would submit to the court that absolutely the least likely thing that happened in this case was that Mr. Kelly, who's a law-abiding citizen, randomly decided to go outside of his house and start shooting at unarmed people. That just doesn't comport with who he is, does not comport with his behavior as a law-abiding person, and it just does not comport with the physical evidence that we have in this case. Most likely thing that happened is that what Mr. Kelly and his wife described is exactly what took place. Your Honor, the Arizona Constitution requires a person to be bailable with sufficient sureties. And the amount of a surety is determined based on various factors, assuring the presence of the defendant,
Yeah, base.
stopping the intimidation of witnesses, and protecting the victim or any other person in the community. In this case, Your Honor, Mr. Kelly's obviously not a flight risk. There's no indication that he would intimidate any witnesses. He does not know who any of these witnesses are, has no way to contact them. And he's not a danger to any person or to the community. His long history of law-abiding behavior is a testament to that. The rules of procedure require that any person before conviction enjoys the presumption of innocence. In the eyes of the law today, Mr. Kelly is an innocent man.
Yes.
And the rules of procedure require that any person charged with an offense must be released on their own recognizance, must, unless there is sufficient reason to believe that a bond or a surety is necessary, and that bond or surety must be the least onerous in order to accomplish the needs of justice. The rules of procedure require that, and the statutory factors that Your Honor must consider are laid out in 1339. We detailed those in the pleadings that we filed, and I'm not going to go over those again here today because I think we've got sufficient detail in the pleadings. I reached out to a number of bonding companies just to discuss what's typical in cases involving first-degree murder, and I got an answer of $250,000 to $500,000 with a surety. These bonding companies were very surprised to see all cash, but that's what I'm hearing from the bonding companies.
Oh,
On
man.
one occasion,
She
I
just
did
called out the
see a
judge
$1
a little
million
bit.
cash bond in a first-degree murder
Woo.
up in Pima County.
Woo.
And that case involved a defendant who had been released from prison for violent offenses, was on probation, was accused of first-degree murder, and who had ties to Mexico. In that case, a $1 million cash bond was imposed. And even in that case, the bond was
Beautiful
reduced
work.
after some arguments were to be. I'm almost wrapping up here, Your Honor. One thing I wanted the court to know, too, is there are certain factors that cannot be considered by the court in making a bond determination. Any threats or mean comments that have been made to the court, to the county attorney's office, to the sheriff's department, to myself, or to any other person, those are things that cannot be considered when determining. Kelly has absolutely nothing to do with any such comments or any such threats, and he's very upset and disappointed that there are people out there who have taken it upon themselves to engage in that activity. And, Your Honor, cannot consider the mob or political pressure in determining what sort of bond is appropriate. In the final analysis, Your Honor, here I would just submit to the court that Mr. Kelly has lived here for decades with no problems whatsoever. He's an elderly gentleman. He has no reason to flee, and he has no place to go. He's extremely recognizable due to all the publicity that's occurred in this case. He's willing to surrender his passport. He's willing to do ankle monitoring. All of that stuff he's willing to do. There's been a significant amount of fundraising that's been taking place. And I would submit to Your Honor that converting this bond to a surety bond would actually make Mr. Kelly less of a flight risk than keeping it as a cash bond, because with a surety bond, he's putting up his own land, his own property, essentially everything that he has, and he's not going to run away from that. He's very concerned about his wife, Wanda. He wants to be there for her. That's her property. That's what she has. Mr. Kelly's not a flight risk or a danger. So we'd ask that Your Honor either release him on his own recognizance or reduce and convert the bond to $250,000 surety.
Wow.
If Your Honor is inclined to continue the $1 million bond, we ask that it be converted to a surety.
Outstanding.
Thank you, Ms. Larkin. If I could have a response from the state.
Outstanding.
Thank you, Your Honor. Your Honor, first I'd just like to point out that in my opposition, I noted that we are not providing all of the details that we have at this time.
Yeah,
The
we
reason
know.
for that is that we don't want all of the details of the witness statements into the media.
Come on.
The reason for that is, as I've indicated, we know, even based on the defendant's statements, that at least 8 people were present in the group in which this incident happened. So we don't want all those details out
Why?
at this time. So we're trying to be circumspect about what it is that we're providing to the court. I'm also going to be brief today, Your Honor, because I've outlined the state's opposition to the motion in the opposition I filed yesterday. Your Honor, basically it's the state's position that Mr. Kelly shot an unarmed man in the back in an unprovoked attack as he ran for his life.
Okay.
There was no warning, and the victim was more than 100 yards from the defendant's residence when he was shot and killed.
According to their
At least
statements.
2 other victims were with Mr. Kelly, or were with the victim as he fled, and they were also shot at. Those 2 victims have come forward and given their statements. Luckily, they escaped with their lives. No one in the group, in the victim's group, were armed in any way. No one had any weapons, according to the witnesses.
According to them, yeah.
Your Honor, it's the state's position that the court's bond, based on the facts of this case and based on what we've outlined in our opposition, is appropriate. The state is also asking that the court impose a no-contact order with respect to victim representatives
She about to
JR,
finish up?
YC,
Yikes.
DC, and victims D, R-R, and RF-G. Thank you, Your Honor.
Wow. Okay. Not much.
Briefly, Your Honor, I would say that the facts as stated by the case are really, it's really mere speculation.
Yeah.
There are no forensics. There have, and this claim that nobody was armed surfaces after there's been plenty of opportunity
Yeah.
for these armed traffickers to.
Of course. No.
We don't object to a no contact order.
Yeah, that's fine. He's not going to contact them at all. The government got blown out right there. You just saw a blowout. Okay, like 11 out of 10
So
for the
based on the
defense.
information that has been provided to the court, at this time, what I'm going to do is I'm going to go ahead and keep the $1 million bond,
Ugh.
but I will make it a surety.
Ugh.
Okay? So that will change from cash to surety.
Okay.
Now, at this time, I'm also going to go ahead and impose to make sure that the victims are included on the restrictions. And one of the other things I want to go ahead and state to you is to both parties is that, as you know, with Rule 5.1, the preliminary hearing, you have to have that within 10 days, right? You ask for a 2-week continuance, and it appears that by the filings that have been provided to the court, I'm going to go ahead and set this up for a preliminary hearing on Friday at 9 o'clock in the morning. So make sure that you have your witnesses and your law enforcement officers ready to be here on Friday at 9 o'clock.
Okay.
Your Honor, for the record, I'd object to that. We'd be requesting a continuance of approximately 30 to 60 days. We do have experts that we're engaging to collect that forensic evidence and do that investigation. I think that would be crucial at a preliminary hearing, even at the probable
Okay.
cause phase.
We're going to break this
We
down.
would be willing to waive time. My understanding of the rule is that's the defendant's right to have a speedy preliminary hearing. It's It's not necessarily the state's right to insist that it be held that quickly. If the state wants a quick determination of probable cause, they can take this case to a grand jury.
They can, yeah.
But we would be asking for a continuance so that we can have that expert input prior to a preliminary hearing. Expert reports are admissible at a preliminary hearing. That's what I would say, Your Honor.
So I'm going to go ahead and deny the continuance.
Okay.
I'm going to go ahead and set the preliminary hearing for Friday at 9 o'clock in the morning. I think one of the concerns that you had was some of the information that had been provided. So if those concerns are there, this is the time to go ahead and voice them at the preliminary hearing. The other thing, too, is that remember that this court is just probable cause. That's all we have to have before it's bound over to Superior Court.
Yep.
So at this time, it's going to be set for Friday. Make sure that you're all ready with your witnesses and with your law enforcement officers. At this time, I'm going to go ahead then, Mr. Kelly. I'm going to continue to hold you on the $1 million bond, but it will be a surety bond. If you post a bond and you're released, these are going to be your conditions. Notify the court of any change of address, appear to all your hearings, and you're not to violate any laws. You're not to leave the state without written permission from the courts. You're to be in contact with your attorney at all times. You're not to drive without a valid driver's license. You're not to possess any firearms or illegal drugs. If required by the court, you may be drug or alcohol tested. You're not to have any contact with the victims with the initials of R, F, G, D, R, R, and you're not to have any contact with the deceased victim representatives with the initials of J, R, Y, C, and D, C.
Great.
Is that
He's not going to
understood?
talk to him, yeah.
You to complete the bottom portion of the form, please. Okay.
All right, so filling out the forms, they're going to bring over some forms for him to sign to make sure. Remember, he got arraigned on the 2 new charges. She waived the new charges, said we're not going to go through the formal readings of both of the aggravated assault charges. So the judges, sort of flew through that, but he still needs to acknowledge them, formally sign for him, just like he did last time. So they're going to be preparing a bunch of additional paperwork, and they're going to be hanging out for a little bit. But boy, we can summarize this. I mean, can we just say ultra shout out to defense attorney extraordinaire Brenna Larkin out there sitting at the defense table? That was outstanding. I mean, that was one of the best arguments I think I've ever heard for a motion to modify release conditions. Really, really great. She was talking about the law. I mean, she went through the law, talking about in Arizona, the presumption of innocence and sort of what the presumption needs to be in order to keep somebody. Talked about the weight of the evidence and sort of how it mattered. In this case, it was all hearsay essentially, and the government corroborated that in their response. So it was nuts. She talked about policy, which I thought was a super bold move here, especially in this jurisdiction because of the location of this jurisdiction. Because I got to imagine this is a very sensitive topic, a sensitive issue. And she says, "Yeah, these people are coming across everybody's borderlands here, and they're going to be engaging with homeowners. And if this case if we lose this case, it's going to set a terrible precedent that's going to snowball throughout the rest of the border," which I thought was great. Now it's great, first of all, from like sort of a red meat, hey, the border's broken policy perspective.
Anything else from the state at this time?
No, thank you, Your Honor.
Larkin from defense? Very well. Please wait for your copies as here it is adjourned.
All right. All right. But remember, it is now going to be, right, if this case, let's say, does go to trial, who's going to make up the jury? Probably some people who live in the area, right? Probably some other people who own property in the area who are going to have some concerns if this precedent is allowed to set. All right, so they just killed the feed. It looks like they ended the Zoom meeting. But my goodness, so that was pretty interesting. We'll let it kick us out here. Yeah, it looks like it's done. So very interesting. So a really amazing job there by Brenna Larkin. She hit the policy. She talked about the border. She talked about mitigation, right? A lot of the same stuff that was in the filing, we heard her sort of reiterate, but she did a great job. Said no criminality at all from this gentleman. He did everything by the book. Everything they said was all total hearsay. And she did her homework with the bond company, which I thought was just beautiful. She called around and she kind of stuck it to the judge a little bit, without saying that. And all due respect to everybody here, these are, also Arizona lawyers here. And it was a funny situation because she said, well, Judge, you put $1 million on him, but I called a bunch of other people and 250,000 to 500,000. I don't know why they do that, Judge. But just letting you know, that's the going rate. So really good. The prosecution did a pretty terrible, job, in my opinion. They didn't say much of anything. They didn't provide any real details. They just said, well, we can't talk about this stuff due to the integrity of the investigation. She read through her little statement and she just flipped through those pages. And boy, I felt like she came very unprepared for that line of argument. But I don't know if maybe they don't have much evidence or maybe they do have evidence. Now, what's going to be very interesting is what takes place this Friday, which will be the preliminary hearing, because the preliminary hearing, it is sort of like a mini trial, right? You actually have evidence. You don't have to prove somebody guilty beyond a reasonable doubt like you would in a regular trial, but you do have to prove somebody guilty beyond a probable cause, right? It's a much lower standard. And so it's to get that from this category of sort of a preliminary phase into a full-blown felony. Currently, they're in the Justice Court. It's going to be bound over to the Superior Court if they establish probable cause. So now the question becomes, on Friday, is the government going to have all of their witnesses available there? Who's going to come in and testify? Are they going to bring in these individuals to come in and testify who are illegal migrants? I'm not sure that they're going to want to do that at this stage because of credibility issues, because of all of the problems that Ms. Larkin raised. So typically what happens in these cases is there isn't a preliminary hearing on them. The preliminary hearing ultimately gets dismissed, and that's because there's an indictment proceeding, and he's indicted right before the preliminary hearing. So the judge, I think, kind of knows that. He probably knows that there is already an indictment forthgoing right now. So we might see, like literally back to back tomorrow on Thursday, we might see an indictment come out. But this was the rest of their argument. This is really what she kind of glossed over. This was the prosecutor's argument. And she flew through this, right? She said, he just started shooting at them. Now, the judge didn't really alter this bond. Of course, the judge changed it from a cash bond into a surety bond, which is good news because that means that I would imagine he's got probably a nice chunk of land down there, and I don't know what it's worth, but maybe it hits that number, and he can just post that up as collateral with the bail bonds company, and then hopefully get out of custody. We'll see. But just so we can see sort of what the government is alleging, this is the rest of their motion. This is why they were opposing the reduction of bond in any way. They said the DRR was just one step behind Gabriel, which we already knew that name, and he heard Gabriel call out in Spanish, "I'm hit," grab his chest and fall to the ground. He saw Gabriel's eyes roll into the back of the head. When he could only see the whites of his eyes, he knew that he was dead. All right, so that's very much like emotional language, right? Pulling on those emotional heartstrings. He felt like they were being hunted the way the shooter came out of the brush. Both RFG and DRR continued to run away from the shooter south towards Mexico. Kelly shot at least 8 rounds at him without warning and unprovoked while they fled for their lives, unarmed and unable to defend themselves, right? And that's all according to them. So unless there's more evidence, I'm still waiting for, the Ring security camera and the footage there. The group all ran back south towards Mexico. They both jumped the fence and made it back into Mexico. That's how close they were to Mexico, like literally on the border. Both of them are willing and able to testify. We'll see how that goes, right? We'll see how that goes. There's all sorts of credibility issues with that. And, not to mention that they were breaking the law and trespassing on his property in the first place. Kelly provided conflicting information. They said that when the incident began, instead of calling 911, he called Border Patrol on his cell phone. He said, "I'm being shot at and I'm shooting back," he said. He said, he couldn't talk and they were headed southbound. All right. So that sounds like that might be a 911 call. Official transcripts are pending. So we'll see, right? Maybe there's more evidence here that we just haven't seen yet. Approximately 6 minutes later, Kelly called Agent Morsell again. This time, Kelly said he lost visual of the suspects running towards Keno Springs. When Agent Morsell asked if he was being shot at, Kelly claimed he had heard a gunshot in his direction. He saw his horse running and he was inspecting his horse, but he didn't appear to be struck. Kelly said it was too far to tell if they had any firearms. Okay, so they're saying now that's inconsistent. Border Patrol agents and sheriff deputies responded to the scene and walked to the property. They did not locate anything at the time. Kelly called Agent Morsell again at 4:23. By this time, his story had changed significantly. He told Agent Morsell he was sitting in the house with his wife. We heard a gunshot, which isn't all that different, right? Okay, we versus I, okay. And Kelly went out on his porch and saw his horse running by. He said he saw 10 subjects all loaded down with AR rifles. He said his wife, Wanda, saw it too. He then claimed it was 10 to 15 subjects. Okay, so right, this is how I envisioned the conversation going. Okay, how many people was it? It was like 5 to 10? Okay, well, we heard about like another group of 8 to 10. Could it have been 8 to 10? Yeah, could have been 15 maybe. I don't know, And it's that conversation and they just tease out the stuff that makes him look bad. Then at 5:23, Kelly tried calling Agent Morsell again. He left a voicemail saying, "You need to call me immediately. This is serious. Call me immediately. I can't say more over the phone." Agent Morsell returned his call at 5:35 p.m. At this point, Kelly's tone had completely changed. He sounded nervous or scared. He said, "This is worse than you can imagine. This is bad." Kelly told him he needed Morsell to send the Border Patrol because this is a border-related issue. When Morsell requested details, Kelly continued to be evasive, said, "This is bad. I need someone to respond out here." He said, "You know how shots were fired earlier? Something was possibly shot. I can't say more over the phone," said Kelly. Kelly then asked Morrill if this is being reported. He said, "Everything's being reported." So then the sheriff received a call at 911 at 5:56 p.m. Sheriff responded to Kelly's residence and met with him. One of the deputies turned on the recorder on his phone, talked to Kelly. Kelly told him there was a shot fired, but he didn't know what it was about. He went out to get his horse. He said, "Walked all over," claimed maybe this happened after you left, referring to the earlier visit. He said, "There's a body right over there. As soon as I saw it, I backed away from it." Kelly said he was in no way being a judge of this, but he claimed the deceased was a mule, a drug runner, is what he said. Kelly said the deceased had a small pack on his back. He said, "As you know, we saw 5 to 10 drug runners coming through with large backpacks. He's in camo. He's a drug runner." He said that as soon as he found him, he called Border Patrol. He claimed he didn't know how to call the sheriff. He said he didn't know what happened to the victim. He then told deputies, quote, "If you were me, you got no idea. You know what I'm saying?" is what he said. And they put that in bold. He then said, "You will not need an EMT, but you'll need a coroner. Wife says they walked all over there. It could be the body could have expired after you all were here. There's stuff running around all over the place all the time." So after deputies located the body, Sergeant Rodriguez began talking with Kelly. Kelly told deputies that he left a flashlight in a tree near the body so they could find it. As they were walking toward the location of the deceased body, Kelly told deputies that rigor was starting to set in. Once they arrived at the body, Kelly asked deputies if it was blood on the body. This was inconsistent with his comments about rigor setting in. So Rodriguez checked the body, determined Gabriel was deceased, and rigor was, in fact, setting in. Kelly then mentioned that he had a medical background. He knew the person was dead. Kelly also mentioned the bullet going through the lung and the heart. Sergeant Rodriguez then examined the body, which was initially face down, and observed the location of the entry on the upper right torso and exit through the center of the chest. Rodriguez could not see the exit wound until he repositioned the body. However, Kelly's observation that the projectile went through the lung and the heart was consistent with the wounds and inconsistent with the earlier statement. As soon as he saw the body, he backed away. All right, so basically they're saying, this guy seems to know a lot about this body. And he said he didn't spend much time with it, but he knows exactly where the bullet went in, and so, I don't know, it's kind of weird. Later, Kelly spoke with the detectives at the sheriff's department. After initially denying he shot at the group, he later admitted shooting. So we're presumably going to get the body cams and jail footage and all of that recorded info. He claimed he directed his shots over the heads of the group. All right, so maybe he just was a little bit low. So the government says, right, that's their version of the facts. A lot of hearsay there. Now, part of these are going to be problematic statements, right? Basically, what this tells me is that at this moment, the only evidence that we have here from the pleadings is basically he said, she said, Kelly's statements, Kelly's wife's statements versus the illegal immigrant statements and their witness statements. And then we have Kelly's own statements, right? And each one of those statements you'd have to parse out and literally, basically create a spreadsheet and say, well, how do we refute each one of these? And maybe you can. Maybe it's very easy, right? All of these are just picked out of context. And, he admitted shooting. Yeah, he that's been consistent. But now it's over the heads of the group, right? And so we're now sort of trying to tease out where the modifiers to the language are and then piece it together. So this is all law and analysis. So they're going to give us the law, which we'll fast forward through. You can see they're sort of doing his call and response. They say, well, he poses a danger. Why? Because Kelly shot an unarmed man in the back as he was fleeing without warning or provocation. Well, I mean, they were sort of provoking him by being on his property illegally. Is that not provocation? Are you just allowed to do that? Mr. Prosecutor, are you cool if somebody just rummages onto your property wherever you live? While the individuals were passing through his very large 170-acre property, so all of that, if he can put that up into a bond, maybe he can get out of custody. Posed no threat to him or his family. Despite this, Kelly shot at them repeatedly with an AK-47, striking and killing one of them unprovoked. Therefore, he's a danger. So the rest of this, right, is their argument. They say in conclusion, $1 million bond in cash is totally appropriate based on the foregoing. They submitted that. So that's who we heard from, apparently, was Kimberly Hunley, the chief deputy county attorney over there. And they will be back on Friday, of course, for the preliminary hearing. We'll see what happened with all the court website and all the court stuff. They deleted the docket from us. They deleted the YouTube video from us. But turns out it was just probably some clerical stuff that they were moving around and not a big deal at all. The hearing went on. And of course, we will come back on Friday to see if the preliminary hearing happens. I'm not so sure that it's going to be a big hearing. It's probably just going to be, maybe it will be. I could be wrong. But we'll have to see. But that, my friends, is going to be it for us on this very short, well, it's not that short, turned out to be a little longer than I thought, early morning stream over here. We will be back tonight for the Watching the Watchers live show, as usual. We'll see what the news has in store for us. But today we are going to leave you, YouTube and Rumble and our Twitter friends, and we're going to go back over to Locals. So Locals, hang tight. We're going to talk about our chat, our persistent chat program, and some other headlines out there. Everybody else out there, make it a great day. I'll see you right back here this evening. Until then, my friends, bye-bye.